Good day, Dean. Good day, classmates. This is Miss Makalam, and I am going to report the Safe Spaces Act, or Republic Act number 11313, or commonly known as the Bawal Bastos Law. Republic Act number 11313, or the Safe Spaces Act, was signed into law last April 17, 2019. Also, the implementing rules and regulations was approved on October 28, 2019. What is the objective of this law? First, to address existing gaps and issues in equality, security, and safety of both men and women in private and public spaces. Also, to address gender-based sexual harassment. Ang batas na ito ay naglalayon na maprotektahan ang mga biktima at mapatawan ng karampatang parusa ang mga sexual harassers. According to the Section 2 of RA 11313, it is the policy of the state to value the dignity of every human person and guarantee full respect for human rights. It is likewise the policy of the state to recognize the role of women in nation building and ensure the fundamental equality before the law of women and men. The state also recognizes that both men and women must have equality, security, and safety, not only in private but also on the streets, public spaces, online, workplaces, and educational and training institutions. So what does the Safe Spaces Act cover? It covers all forms of gender-based sexual harassment committed in public spaces, educational or training institution, workplace, as well as online space. So what do we mean by gender-based streets and public spaces sexual harassment? GBSH in street and public spaces is defined as acts which are committed through any unwanted and uninvited sexual actions or remarks against any person, regardless of the motive for committing such action or remarks. What do public spaces refer to under this law? It refers to streets and alleys, roads and sidewalks, buildings, restaurants and cafes, public parks, schools and churches, government offices, public parks, malls and public markets, as well as public washrooms. What do public spaces refer to under this law? It also refers to spaces used as evacuation centers, public utility vehicles, public vehicles covered by app-based transport network service. It covers recreational spaces such as but not limited to cinema halls, theaters and spa, bars and clubs, resort and water parks, hotels and casinos, internet shops, and all other areas regardless of ownership, openly accessible or offered to be accessed by the public. So what are the acts of gender-based sexual harassment in public spaces? According to Section 3A of this law, first, catcalling or unwanted remarks directed towards a person, commonly done in the form of wolf whistling or paninipol, misogynistic, transphobic, homophobic, and sexist slurs, as well as unwanted invitations. What do we mean by sexist remarks? It refers to slur statements that are indicative of prejudice, stereotyping, or discrimination on the basis of sex, typically against women. It also covers misogynistic remarks or slur statements that are indicative of the feeling of hating women or the belief that the men are inherently better than women. Please read the example of these remarks. It also covers transphobic remarks or slur statements that are indicative of fear, hatred, or aversion towards persons whose gender identity and/or expression do not conform with their sex assigned at birth. Please read some of the examples of transphobic remarks. Now, what are the acts of gender-based sexual harassment in public spaces? It also covers B. Persistent and invited comments or gestures on a person's appearance. C. Relentless request for personal details. D. Statement of sexual comments and suggestions. E. Public masturbation or flashing of private parts, groping, making offensive body gestures at someone, and other similar lewd sexual actions. F. Any advances, whether verbal or physical, that is unwanted and has threatened one's sense of personal space and physical safety. This may include cursing, leering, and intrusive gazing and taunting. Letter G. Persistent telling of sexual jokes, use of sexual names, and it also covers letter H. Stalking or conduct directed at a person involving the repeated visual or physical proximity, non-consensual communication, or a combination thereof, that cause or will likely cause a person to fear for one's own safety or the safety of others or to suffer emotional distress. So what are the penalties for the GBSH in public spaces? According to the law, penalties vary according to the act of GBSH committed and how often a person was convicted for violating the laws. For verbal violations, for first offense, the penalty would be 12 hours community service inclusive of gender-sensitive training and 1,000 peso fine. For second offense, imprisonment of 6 to 10 days or 3,000 peso fine. For third offense, imprisonment of 11 to 30 days and 10,000 peso fine. For the demonstrated violation, first offense would be 12 hours of community service inclusive of gender sensitivity training and 10,000 peso fine. Second offense, imprisonment of 11 to 30 days or 15,000 peso fine. And for third offense of the demonstrated violations of the gender-based sexual harassment, the penalty would be imprisonment of 1 month and 1 day to 9 months and 20,000 peso fine. This is according to Section 12B of RA 11313 IRR. Now, for gender-based sexual harassment through stalking and physical advances, such as touching, pinching, or brushing against the genitalia, groin, or breast, first offense punishment would be imprisonment of 11 to 30 days or a fine of 30,000, provided that it includes attendance in a gender sensitivity training to be conducted by PNP in coordination with the local government unit and the Philippine Commission for Women. The penalty for second offense is imprisonment of 1 month and 1 day to 6 months, or 50,000 peso fine. The third offense is imprisonment of 4 months and 1 day to 6 months, or 100,000 peso fine. This is in accordance to Section 12C of RA 11313 IRR. Where can victims of gender-based sexual harassment in street and public spaces seek assistance? In all cases, the victim can seek assistance from the local government unit via local anti-sexual harassment hotline, the nearest police precinct through their Women and Children's Protection Desks, local social welfare and development office, public attorney's office, subject to the public attorney's office person qualified for legal assistance procedure. For the victims on the streets, roads, alleyways, and parks, they may seek assistance from the local traffic enforcer. For the victims who are in a public utility vehicles by a driver or operator of PUV, the victim can seek assistance from the local traffic enforcer, LTO or LTFRB. For the victims who are in close proximity to the local government unit hall, they may seek assistance to the Anti-Sexual Harassment Desk Office of the LGU, either in provincial, municipal, city, or barangay. For the victims who are in the malls, bars, or public establishments, they may seek assistance from the Anti-Sexual Harassment Designated Officer designated by operator of establishment, for example, the security officers. Now, what do we mean by gender-based online sexual harassment? Can you guess? Gender-based online sexual harassment includes acts that use information and communications technology in terrorizing and intimidating victims through threats, physical, psychological, and emotional, unwanted sexual, misogynistic, transphobic, homophobic, and sexist remarks and comments online, whether publicly or through direct and private messages. It could also be through invasion of the victim's privacy through cyberstalking and incessant messaging, or uploading and sharing without the consent of the victim any form of media that contains photos, voice, or video with sexual content. Gender-based online sexual harassment also includes acts that use information and communications technology in terrorizing and intimidating victims through any unauthorized reporting and sharing of any of the victim's photos, videos, or any information online, or impersonating identities of victims online or posting lies about victims to harm their reputation, or filing false abuse reports to online platforms to silence victims. So what are the penalties for online gender-based sexual harassment? The penalty to the violation of this is prison correctional in its medium period or imprisonment of 6 months and 1 day to 2 years and 4 months, or a fine not less than 100,000 pesos but not more than 500,000, or both at the discretion of the court. If the perpetrator is a juridical person, its license or franchise shall be automatically deemed revoked, and the persons liable shall be the officers thereof, including the editor or reporter in the case of print media, and the station manager, editor, and broadcaster in case of broadcast media. An alien or foreigner who commits gender-based online sexual harassment shall be subjected to deportation proceedings after serving sentence and payment of fines. So where can a victim of online gender-based sexual harassment file a complaint? The victim can file a complaint directly with the National Bureau of Investigation through its Cybercrime Division, the Philippine National Police Anti-Cybercrime Group, or the Office of the Cybercrime of the Department of Justice. So here are some practical tips in saving digital evidence and online report. First, take note of the Uniform Resource Locator or URL or the web address of the website or social media account of the perpetrator. Second, make a printout of the content being complained of by opening a browser, such as Google Chrome, Mozilla Firefox, etc., on a laptop or desktop, going to the pertinent account or page, and print the said web page. You may also contact authorities via PNP's Anti-Cybercrime Group's e-complaint desk at this link or through their complaint action centers. Moving forward, let us discuss the gender-based sexual harassment in workplaces. So gender-based sexual harassment in the workplace includes the following. A. An act or series of acts involving any unwelcome sexual advances, request, or demand for sexual favors, or any act of sexual nature, whether done verbally, physically, or through the use of technology, such as text messaging or electronic mail, or through any other forms of information and communication systems that has or could have a detrimental effect on the conditions of an individual's employment or education, job performance, or opportunities. B. A conduct of sexual nature and other conduct based on sex affecting the dignity of a person which is unwelcome, unreasonable, and offensive to the recipient, whether done verbally, physically, or through the use of technology such as text messaging or electronic mail, or through any other forms of information and communication systems. C. It also includes a conduct that is unwelcome and pervasive and creates an intimidating, hostile, or humiliating environment for the recipient. Workplaces herein include all sites, locations, spaces where work is being undertaken by an employee within or outside the premises of the usual place of business of the employer. Is sexual harassment between peers or by a subordinate to a superior now covered under this law? The answer: yes. The first law to penalize sexual harassment, or Anti-Sexual Harassment Act of 1995, recognized that sexual harassment occurs in work, education, and training environments. However, it requires the existence of authority, influence, or moral ascendancy between the offender and the offended party. It did not specifically address the issue of hostile environment resulting from sexual harassment between peers or co-employees, or those committed against a superior. The Safe Spaces Act addresses these gaps by recognizing that sexual harassment can be committed between peers or by a subordinate to a superior officer. What can a victim of workplace GBSH do? The victim can file an administrative complaint with the Committee on Decorum and Investigation and/or file a civil and/or criminal case before courts. What are the responsibilities of employers under this Act? Under the Safe Spaces Act, employers must: A. Disseminate or post in a conspicuous place a copy of the law to all persons in the workplace. B. Provide measures to prevent gender-based sexual harassment in the workplace, such as the conduct of anti-sexual harassment seminars. C. Create an independent internal mechanism or a committee on decorum and investigation to investigate and address complaints of gender-based sexual harassment. D. Develop and disseminate, in consultation with all persons in the workplace, a code of conduct or workplace policy which shall: E. expressly reiterate the prohibition on gender-based sexual harassment. And F. Describe the procedures of the internal mechanism. G. To set administrative penalties. What are the penalties for the employers? For failure to implement their duties under the law, there is a penalty of fine of not less than 5,000 but not more than 10,000. For non-action on reported acts of gender-based sexual harassment in the workplace, there is a fine of not less than 10,000 but not more than 15,000. So offenders of gender-based sexual harassment in education and training environment may be committed by principals, school heads, teachers, instructors, professors, coaches, and trainers, or by any person who has authority, influence, or moral ascendancy over another student and trainees. So what are the duties of the heads of educational and training institution under the Safe Spaces Act? The same requirements and corresponding penalties imposable upon employers are also applicable to heads of educational and training institutions. So these heads are also required to disseminate the law, develop their own code of conduct, and establish and/or update the composition of the Committee on Decorum and Investigation. Note that these heads have to harmonize the CODI for their employees and for their students. For the school heads and heads of training institutions covered by the Commission on Higher Education, Department of Education, and the Technical Education and Skills Development Authority or TESDA shall comply with the standards set by the agency. The CODI to be established by the education and training institution should be composed of representatives from the school administration, the trainers, instructors, professors or coaches, and students or trainees, students and parents as the case may be. Designate a woman as its head and less than half of its members should be women. Be composed of members who should be impartial and not connected or related to the alleged perpetrator. Investigate and decide on the complaint within 10 days or less upon receipt thereof. To observe due process, protect the complainant from retaliation without causing her or him any disadvantage, diminution of benefits, or displacement, and without compromising his or her security of tenure. And guarantee gender-sensitive handling of cases and confidentiality to the greatest extent possible. As to the fine, school or institution heads who did not implement their duties under the law may be penalized with a fine ranging from 5,000 to 10,000. And school heads or institution heads who did not act on reported gender-based sexual harassment in their institution may be fined with 10,000 to 15,000. That's all for the Safe Spaces Act. Thank you so much for listening and have a good day.